For January 19th, 2023. Thanks everyone for being in attendance. Rosalie, would you please take attendance?
Chairman Loper,
Present.
Vice Chairperson, Member Cardin,
Present.
Member Ward,
Present.
Member Schwartz.
Here.
Chairman, we have a quorum.
I'll be quiet, so I'll take. I'd like to say you've done a great job doing this so far. So how about if I nominate you for another term, if we can do that as chairman? If it's not broken, we shouldn't try to fix it.
Well, I appreciate that. We have a motion for me.
Excuse me, Mr. Chairman, these are elections, so it's a nomination. You need a second, and then you have to see if there are any other nominations.
So I nominate. It's a nomination.
Looking.
Second.
Sorry, my mic was off. See how good I run this? Member Cardin, did you have a
Second?
Second by Member Cardin. Rosalie, would you please take?
You have to ask if there are any other nominations.
See, you spoke way too soon. Are there any other nominations for chair? Anybody in the audience wants to be chair? All right. Seeing none, I'll close the nomination for chair and ask Rosalie to please process a roll call vote.
Member Cardin,
Aye.
Member Schwartz,
Aye.
Member Ward.
Enthusiastically, aye.
Vice Chairperson's not here, and Chairman Loper.
I'll abstain.
Okay. Chairman, that's an approval by a vote of 3-0 for Chairman Loper to serve as chair again.
Thank you, everyone. Checks are in the mail. Move on to the vice chair. That's currently Member Person. She's not in attendance today. Member Ward?
Oh, I would like to nominate Member Cardone for the vice chair position.
I'm flattered. I agree with Member Schwartz. If it's not broken, don't fix it. And she's not here to defend herself.
I could go with that one too.
We're doing elections. Vice chair.
Oh, she just arrived to defend herself?
I'm scared. Let's do this quickly.
No, it's all right. We just did. So do we have a nomination then for vice chair from a member of the board?
May I nominate Member Person?
And I would second that.
All right, we have a nomination from Member Cardin and a second by Member Ward. Rosalie, would you please take roll call vote?
Member Cardin,
Yes.
Member Schwartz,
Yes.
Member Ward,
Yes.
Chairman Loper,
Yes.
Vice Chairperson.
Yes, and I don't know if you need to do something different since I missed the attendance call.
Okay. Chairman, that's an approval by a vote of 5-0 for Vice Chairperson to serve as vice chair again.
Thank you, and thank you for your serving on the board. All right, we'll move on to, not to do that, to the minutes of November 10th, 2022 hearing. Are there any comments by any board members? Seeing none, they're considered approved. Move on to the announcements. One, this meeting has been noticed in accordance with open meeting laws of ARS 38-431. Agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office and are also available on the Planning and Development website 1 week prior to the hearing at www.maricopa.gov/planning. With respect to the hearing process, cases will be considered in the order they appear on the agenda unless otherwise agreed to by the board. We have no changes to the agenda at this time. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony on a particular case shall notify the board of such interest. This shall be done by filling out a speaker's card. Looks like this one. And they are available from Rosalie at my left, far left at the dais, close to the dais. And please fill that out. Or you can register your desire to comment as noted on the published agenda. Also, at the appropriate time for each case, the chair will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on the icon on the webinar screen. Staff will provide the chair with the names of persons who have registered and noted a desire to comment, and those registered participants who have raised their hand. The chair will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the actual amount of time allowed for testimony shall be at the discretion of the chair. The chair will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chairman regarding public comment. All votes will be done by roll call vote only. And the chair will verbally identify the specific board members responsible for all motions and seconds. And with that, we'll move on to the withdrawn agenda.
Mr. Chairman, board members, real quickly, we have 3 cases that are withdrawn, no action is necessary. They are BA 2022-047, known as the Cook Trujillo property, BA 2022-048, known as Arizona Avenue Dispensary, and BA 2022-057, known as Papa Sony LLC.
All right, and those were withdrawn, so there's no action on our part. Move on to consent agenda. We just have one item on the consent agenda, BA 2022-057. I'll turn that over to staff if they have anything to present on.
And Mr. Chairman, for the record, I misspoke. The third item being withdrawn is not the Papa Sony case. It's BA 2022-052, known as 2PHDS LLC property variance.
We all caught that.
Okay, thank you.
Thank you. All right, but on the consent agenda is the Papa Sony project.
That is correct, Mr. Chairman, board members. BA 2022-057 in District 2, the variance to a wall without required transparency within the required front yard in the R18 zoning district at 10555 East Butte Street. There's no known opposition. The findings in paragraph 15 are for approval subject to item A, which would memorialize the variance if approved.
Thank you. Any questions of staff on the consent agenda? All right, seeing none, this is a public hearing, or is there anyone in the audience who wishes to speak on this particular case? And then David, do we have anyone online?
There's no one online.
No one online. All right, go ahead and close the public hearing and turn it to the board members for a motion one way or another.
I move we approve the consent agenda.
We have a motion for approval by member Person. Is there a second?
Second.
We have a second by member Schwartz. Rosalie, if you'd please take a roll call vote for us.
Member Cardon,
Yes.
Member Schwartz,
Yes.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 5-0.
Congratulations to the applicant on that. Move on to next item on our agenda is code compliance review for V as in Victor 2019-02005. Staff, go ahead, presentation.
Yes, Mr. Chairman, board members, this case is located in District 3. It's appeal of the hearing officer's order of judgment for a 4.7 acre site at 912 West Happy Valley Road in the Phoenix area. The violation is for land use without proper zoning entitlement and unpermitted construction. The case was open November 1st, 2019 due to citizen complaints of commercial business activity in residential zone. Compliance agreement was executed February 24th of 2020. Set a compliance deadline of March 1st, 2021. It was later extended on multiple occasions through March 1st, 2022. A notice of violation order to comply / summons mailed to the respondent on September 22nd, emailed to him on September 24th, and posted on site September 26th. It scheduled a administrative hearing on November 8th. The respondent in the form of the Montana Tractor and Plow Company manager attended but left the hearing before it was completed. That was on November 8th. After that hearing, the hearing officer found the respondent responsible for the verified violation of land use without proper zoning entitlement and unpermitted construction. He ordered a $7,500 noncompliance fine and a $175 daily noncompliance fine to accrue until respondent completely ceases business operations. Staff would note compliance could also be achieved through, gained through approved zoning and completed permits. No fine amount has been paid to date post the hearing officer's judgment. I will point out that the respondent did pay previous noncompliance fines in a total amount of $10,000. The property remains non-compliant with the tractor sales business operating in the Rural 43 zoning district, where C3 commercial zoning would be required for the use, and with unpermitted construction, including a building not authorized for occupancy yet occupied by employees and general public customers in the daily course of business operations. On December 6, 2022, the respondent appealed for code enforcement review with oral arguments. The hearing officer made a finding of fact and reached his conclusion pursuant to Section 1502 of the Maricopa County Zoning Ordinance. Pursuant to Article 1504.3.2 of the ordinance, the Board of Adjustment may either affirm the hearing officer's order of judgment or remand it back to the hearing officer due to a finding of procedural error. Staff has reviewed the record, believes the evidence supports the decision of the hearing officer, and can find no procedural error. Staff recommends the board affirm the hearing officer's order of judgment. I'll note this is a very large packet. The applicant has submitted approximately 200, and the respondent has submitted approximately 270 pages of material. The county council objects to the respondent's appellate memorandum, stating that with the exception of pages 16 through 18 at line 22, that all the other arguments are outside the board's jurisdiction when it comes to code enforcement review. So that concludes my presentation, and I'm happy to try and answer any questions you may have.
Great presentation. Darren, are there any questions of staff at this time? Just one, Darren, to confirm or to clarify, based on our past code compliance review cases, our role is explain what exactly are we limited to think about and discuss and act on versus what we cannot?
Mr. Chairman, council may want to go into more detail, but if you find a procedural error such as the respondent was not notified of the administrative hearing before the hearing officer, the respondent was never notified of the violation, what exactly is being violated in the zoning ordinance. Those would be procedural errors.
But we're not to look at the merits of the case itself. That's outside of our purview, correct?
Mr. Chairman, board members, that's my understanding. The amount of ordered noncompliance fines, the actual judgment is outside your purview. It's just, was there procedural error in reaching that judgment?
All right, thank you very much. All right, is the applicant or representative here in attendance today? Come on up to the podium if you can, provide your name for the record, and go ahead with your presentation.
Thank you, ladies and gentlemen of the board, Chair. We have a PowerPoint presentation as we go along. I believe that she's sharing her screen. Yeah.
We have it, so it was 130 megabytes if I sent it with audio. So we have a PowerPoint on here with like the full PowerPoint. Is there any way I can look it up?
And just a quick reminder, the applicant representative, as the staff's mentioned, our role is limited in this. We can't discuss whether or not we believe that the action or what you're doing, that portion of it is not in our purview. It's simply about whether or not there's procedural error. I don't know if that helps cut down on your presentation or not, but just want to make sure that everybody's on the same page.
Thank you, Chair. We understand that that has been the county's position, is that the scope of review here is so limited. We disagree with that legal conclusion, and I have some presentation on that point, but I am going to be as brief as possible. I understand, and I thank you for your time today as well. Thank you. Ladies and gentlemen of the board, this is a very peculiar set of actions by the county. We filed a memorandum that outlines at least 6 points of reversible error with factual support assigned for each error.
Mr. Chairman, if I may.
Mr. Peck, yes, please.
I need to use the microphone because they get mad at me.
Of course, Mr. Peck.
Always be heard. As you know, the Board of Adjustment is statutorily empowered, and you only have 3 powers, one of which to do variances. That has nothing to do here today. The second one is if the Board of Supervisors so decides, you are empowered to hear these kinds of appeals. The Board of Supervisors has given you that jurisdiction, but it's limited. If the applicant believes that your interpretation of your authority is incorrect, you have no jurisdiction to decide your own authority. They would have to file an action on that. So for council to argue that they disagree with how you've decided you have jurisdiction is not something that you could reverse. And I'm only saying that because I think that will help you speed along your hearing.
Thank you, Mr. Peck. Go ahead, back to the applicant.
Thank you. Notwithstanding those comments, I think it's fair to say we disagree, and I think it's fair to see that's how the county intends to proceed with the limited scope. But for the purposes of the record, we want to make sure that those arguments are preserved because, again, I think the statutes say something differently than what the county is arguing.
Mr. Chairman, according to the law in Arizona, the record that will be reviewed if this goes to court is that before the hearing officer, not that before the Board of Adjustment. So that any record they establish here, they may like it, but it's never going to get anywhere.
Okay, thank you.
Again, respectfully, we disagree with that position. I will move on with creating the record. Now, we filed a memorandum that outlines, yes.
Thank you. Yeah, could you provide your name? I don't know if I caught that.
Yes, Jesse Callahan, 135 East Missouri, Phoenix, Arizona, 85012.
Thank you.
Now, we provided a memorandum that outlines 6 points of error. We've cited the record. We pointed to it. We've requested additional documents under the Freedom of Information Act that we still have yet to receive. We did get some that further support the position that we've outlined in writing. Ladies and gentlemen, you also have the staff's response to our 16-page memorandum. And in terms of the substance of the assigned errors, the county failed to cite the record at all. Mr. Gerard, he prepared the response. He did not rebut any of the points of reversible error. All that is stated is that he believes, Mr. Gerard, the evidence supports the decision, and he doesn't know of a procedural error. Now, even Mr. Peck has admitted, ladies and gentlemen of the board, you have the ability to look at the procedural errors, and there are many here. With no citation, no explanation, Mr. Gerard says he doesn't know of one. But what Mr. Gerard did not do, what the county did not do, is explain why the errors that we have assigned aren't actually procedural errors. And if Mr. Gerard, who testified against my client, if he can't explain why he believes we are wrong about these errors, then the board should be very careful to give the county the rubber stamp, the deference that they're seeking. Now, I'm going to move on to page 2 of our PowerPoint here. Now, why did I say that the county is looking for a rubber stamp? They have taken the position that even if what the county did is contrary to the law, contrary to the facts, this board is powerless to correct anything other than some, quote, procedural error. Our position, again, is that is not the law. Now, Mr. Peck's been clear. He doesn't want me to make a presentation on that point. I've outlined that within our PowerPoint, but in the interest of time, I'm going to move on. The third page and the fourth page discuss what the board's jurisdiction is to review an appeal under the statute. And I think what's important for the purposes of this record is to note that the county cannot enact any sort of code provision or procedure that is inconsistent with the statute. The statute confers the rights upon the county to engage in this process, and it's very clear that this board shall affirm the agency action unless the court concludes that the action is contrary to law, is not supported by substantial evidence, is arbitrary and capricious, or is an abuse of discretion. That is our position. That is what the scope of review is. And a zoning ordinance can't limit the board from considering and correcting a decision that is contrary to law. But that's what the county is telling the board it should do. Now, the ordinance itself properly limits the board to administrative review. ARS 11816B3 defines the scope. But regardless of this distinction between procedural errors versus the merits, which I think is important and we shouldn't lose sight of, because the merits do support my client's position, there are at least 4 procedural errors that we have identified that are plain to see on their face. So if the hearing officer committed any one of these procedural errors, even under the interpretation proffered by the county of the board's scope and jurisdiction, the board should still remand the matter for further proceedings. Now let's look at error number 1. Service was patently defective. Now remember, the county's written position is that the staff reviewed the matter and could find no procedural error. But the first procedural error that I'm showing the board is painfully obvious to see when compared to what the hearing officer said and what the statute requires. The statute required personal service. But as the record shows, the hearing officer wouldn't even listen to Colt's owner regarding the statute. If the board agrees with this plain reading of the statute to these facts, then the board is obligated to remand for further proceedings. So what is
Sir, the property was
ARS section 11815E, the zoning inspector shall cause the notice to be personally served on the alleged violator. That did not happen here. Personal service is the cornerstone of our legal system. For a tribunal to obtain jurisdiction over a person, for instance, in a code enforcement proceeding, it has to affect personal service. There are rules, there's case law on what personal service is. It's a summons, it's a notice, and it's served by a licensed process server or served by a sheriff. Personal service is personal. It's served on a person. It is plainly defective to say an email constitutes personal service. It doesn't. It's plainly defective to say dropping off some papers at the property is personal service. That is not personal service, but the statute required it. Now, Colt could have been served through its statutory agent. The county chose not to do that. Colt could have been served by serving process on its principals. The county chose not to do that either. Now, there is no evidence to show in this record that personal service was effectuated. And the quote, notified, that was the language that was used by staff in the presentation just now. Notified isn't the standard in the statute. Personal service is the standard in the statute. The procedural error was the decision that was made by the hearing officer that personal service had been effectuated with no evidence of it. The county can cite to no evidence in the record with an affidavit from a process server or from a sheriff who are licensed to effectuate personal service without actually serving it on a person. I mean, that's why it's called personal service. You serve it on a person. This was not personal service. But here, this is what the hearing officer had to say about personal service. Quote, posting of a summons. That's not what the statute says. The statute would say posting of a summons is sufficient if that's what was actually required, but instead it says something else. This is very basic law. Personal service didn't happen here. That is a defect. Mr. Rainbow appeared at the hearing, pointed out that defect, and the only other thing the hearing officer said in regard to personal service was basically to tell Mr. Rainbow, stop talking. The property was posted, that's notice, that's a summons. That's what he said. But that's actually not personal service consistent with the statute. If the board finds that there is no evidence of personal service, and I will espouse to the court and proffer to the court, there is to the board, there is none here. That in and of itself makes the case easy. We can dispose of it. We can remand because personal service was not effectuated. The board need not inquire any further if the board finds there is not evidence of personal service. And the county hasn't explained why posting meets the requirements of personal service. It doesn't, because it can't, because the statutes don't allow for personal service in that method. When you personally serve somebody, you serve them in person. That did not happen here. Now, not only was service defective, I'm going to move on to error number 2.
Okay, this is a new run proceeding that's directed against Montana Tractor and Plow Company that allows service through posting of a summons on the property. That was accomplished with photo by him therefore concluding that the service was proper and we can proceed. Sir, the property was posted. That's a notice. That's a summons. Sir, stop arguing, please.
That was of the record on personal service. We just played it for the board. That's not personal service.
I'm like Mike.
Record to support that conclusion. Moving on to error number 2.
And code enforcement officer.
Legal representation. So not only was service defective, but Mr. Gerard received a written request for a continuance from my client's former counsel on November 7th. And we know Mr. Gerard received the email before the hearing because he responded to it. That means Mr. Gerard had noticed that Colt did not have the opportunity to secure counsel in the few weeks leading up to the hearing. And Mr. Gerard also had a written request for a continuance in hand before the hearing. But instead, the testimony at the hearing was as follows. Now, if it had been accurate, Mr. Gerard would have said, last night I received a request for a continuance to allow Colt time to retain new counsel because it had not had the time to do so. That was the position that had been provided by my client. But that fact was left out of the record. And in and of itself, it underscores that the decision should be reversed. My client, by statute, is entitled to legal representation at the hearing. He was deprived of that right twofold. First, by the failure to effectuate personal service. And second, through the representation that my client, quote, presumably had time to secure new counsel when Mr. Gerard had been told in writing, he responded to this email, that my client's former counsel stated Colt had not retained new counsel and needed more time to do so. If the board agrees that Colt was entitled to legal representation but denied that right, that finding in and of itself requires the decision to be vacated so that we can represent Colt in this matter and reach the right result below after proper procedure is followed. Error number 3. The failure to continue the hearing violated due process. Now, as the board can see, the procedural errors are piling up. We plainly have defective service, and we have an unrepresented party who explains that he is making a special appearance at the hearing strictly on the basis of defective service. Now, even as a non-lawyer, Colt's manager, Mr. Rainbow, knows that the statute says personal service is required. So he believes everything will be straightened out, the county will follow the law, and that a hearing will be set for another day. But the county denied my client that right. And the hearing officer already warned Mr. Rainbow that he'll waive his argument about service if he makes a general appearance. Mr. Rainbow is clearly at a loss about what to do. He says he needs a lawyer. And even though Mr. Gerard knows that a continuance was requested to afford that opportunity to retain new counsel, even though Mr. Rainbow clearly articulated that he's in over his head to deal with anything beyond the defective service, the hearing officer did not continue the hearing. Now, Mr. Gerard didn't speak up about the continuance request he had received. Instead, the hearing officer repeatedly encourages Mr. Rainbow to leave so they can proceed in his absence without any defense, without anyone to correct the record.
Thank you. If you wish to leave the hearing room, you're free to do so.
No, you're asking me to waive my rights, which is against statute, so thank you.
And the record will reflect that Mr. Rambo has left the hearing. So we will proceed in his absence.
It is a patent violation of my client's due process. None of us here would accept a proceeding to go forward without being served, without the right to afford counsel, and then being asked to leave. The board should not rubber stamp those errors. The board should look at those errors, ask the county to explain how personal service was effectuated in the record. Because the record doesn't have any such evidence, the board should reverse. Error.
So,
Well, that's for the
The lack of competent evidence that was presented, that violated due process. Now, contrary to what Mr. Gerard testified to, my client paid an incredible amount of fees consistent with his efforts under a compliance agreement. And the background and the relationship between the compliance agreement and this proceeding, it's all spelled out in our papers. I'm not going to go into it in detail, but essentially there is an agreement between the county and my client. But Mr. Gerard testified to a fact that is not supported by any evidence and actually disproved by the records that we obtained from the county. My client had paid the fees. The testimony by Mr. Gerard that my client did not pay the fees in and of itself requires a remanding of this proceeding because it is demonstrably false based on the county's own records. Now, the staff now acknowledges, inconsistent with what's in the record below, that my client paid $10,000. even though Mr. Gerard falsely said that the payment hadn't been made. This legal error, this citation, this reference to something that is undermined by the county's own records, in and of itself violated due process and requires that the proceeding be remanded. But that wasn't the only bit of testimony for Mr. Gerard.
Go
ahead.
Okay, now. Notice the last two. One was for payment of outstanding fees. Were those fees set forth in the compliance agreement?
Correct.
And has any of that been paid?
Those have not been paid.
Yet today, the board is being told that $10,000. So the information that was provided to the hearing officer, it was not true. Everybody here today agrees it's not true, but what the county is saying, well, don't look at that. Don't look at the lack of truth in what happened below, and that's not the legal standard I'll proffer to you. Now, for the life of me, I can't understand, nor is there anything in the record to support why he stated the fees had not been paid when they had been paid, but it's easy to see, it's easy to prove, and again, it requires that the proceeding be remanded. A decision predicated on a demonstrable falsity must be remanded. The law on that is indisputable. Now, Mr. Gerard also referred to a trailer, something he knew was a trailer, as a quote, unpermitted building. That's not a building. If Mr. Gerard's testimony is actually contradicted by the county's own records and his own email admitting, and we got this pursuant to our records request, that he knew it was a trailer, not an unpermitted building. Now, what's also troubling in this email is it confirms that Mr. Gerard was motivated to improperly cut off power to my client's property. My client lawfully receives power from APS, yet Mr. Gerard, for some inexplicable reason, wanted to shut it off. Again, this shows that the procedure below was improper, slanted against my client, and not predicated on truth and what's in the record, instead on false information. Now, error number 5, and on page 13 of 19, I'm gonna conclude here soon. I don't want to drone on. The only deference to a decision is if substantial evidence supports it. That's the proper legal standard. This is the Schaefer v. Board of Liquor case. And here are the two quote unquote findings that are unsupported by the record and disproved by the county's own records. First, the hearing officer accepted a legal conclusion that the party's compliance agreement was, quote, nullified. There's no explanation in the record of how or why, under what authority, under what provision, and through what legal proceeding the legally binding compliance agreement was, quote, nullified. Now, we've actually filed suit to obtain a declaratory judgment that it's not a nullity, but regardless of that, there's no evidence in the record that shows the compliance agreement was nullified. Second, the hearing officer based its decision on a finding that the, quote, rezoning hearing had been tabled based on a failure to comply with submitting documentation. The county can cite no evidence in the record to support that allegation. There's no minute entry, there's no transcript, there's no submission that supports the alleged failure to submit documents. So what documents were allegedly not submitted? Who knows? Because no evidence supports it. In truth, my client has been proceeding consistent with the compliance agreement and reliance on it, sought rezoning, and was in the process of obtaining it when the county improperly and simply tabled in perpetuity that application. But that was a violation of the compliance agreement. But for your purposes today, ladies and gentlemen, the county did not provide any evidence supporting those two conclusions. One is a purely legal conclusion for which no deference is afforded below. Error number 6. The judgment is contrary to the facts and the law. The factual finding regarding the tabling was a basis for the judgment, but that's not supported by any evidence. The tabling itself was wrongly admitted as an order contrary to the law, another procedural error, and the conclusory assumption regarding the compliance agreement was contrary to the facts and law. Now, the testimony regarding the, quote, tabling is set forth on page 15 of the PowerPoint. Go ahead, Bishop.
Okay, now let's talk about that. They did have a hearing before the Planning and Zoning Commission, is that correct?
Yes, sir. That's correct.
And it's not my recollection, you reminded me that that particular application was tabled, is that correct?
That is correct.
And was that to give the applicant the opportunity to present updated and additional information?
Yes, it essentially was an indefinite continuance as of September 9, 2021.
Now, turning to the next page, the record and this is the actual record from that quote tabling, the record unequivocally establishes that the rezoning application was tabled seemingly forever with no valid basis. Even Chairman Arnett confirmed my client's rights were being violated. If you look at the quote, Chairman Arnett said, this is a public meeting and he has the right to present if he wants to, and he will leave that decision to the applicant. But because of things that were said that were disparaging against my client, that weren't supported by the record, certain members decided that they were going to approve the tabling forever. So the compliance agreement isn't a nullity. This rezoning application, it wasn't denied for any proper reason. It was just tabled forever. But we heard what Mr. Gerard presented to the hearing officer, which is that it was tabled for some indefinite continuance, which Mr. Peck confirmed would not be permitted to take place. When this happened, there was a request for an indefinite continuance, and Mr. Peck said, you can't do that. And so then they decided, okay, well, we're going to table it, but you can't table it forever either. That is a violation of my client's rights. It was not appropriate, and it wasn't supported by any evidence, and it certainly wasn't supported based upon what happened in this proceeding that's at issue before you, as described by Mr. Gerard. The actual evidence shows something else happened with regard to the tabling, yet another error. Now, for the purposes of this record, what Mr. Gerard told the hearing officer about this tabling, it wasn't true, and we've proven it. That in and of itself was a procedural error, requires reversal and remanding for further proceedings. And ladies and gentlemen, just because something happens to be a procedural error doesn't also mean that it can't be a substantive violation of somebody's rights. And that's what has happened here. There are procedural errors along with them being violations of substantive rights. Now, the status of the compliance agreement is now properly before the Superior Court. The hearing officer didn't have jurisdiction to interpret the compliance agreement, which apparently was done, another procedural error. There's no evidence in the record that the hearing officer even reviewed the compliance agreement, and there's no testimony in the record related to the county's interpretation of any provision of it. The use of tabling and misrepresenting what actually happened to deny my client his rights in this proceeding should not be condoned and requires that the matter be remanded. Now, this is what I'm going to conclude with today. We all have a function here today. Yes, I'm an advocate for my client, but I also fully believe in his case 100%, that valid service did not occur here. My client was denied legal representation, and the excuse given for the county's insistence on depriving my client of its rights, they're not supported by any evidence at all. Rather, they rest on false statements, and we've shown that those statements were false. We've proven it. The fees were paid. My client was in compliance with the compliance agreement and had his rights trampled on in violation of basic tenets of Arizona law. The key here is, what can you do about this today? And I'll proffer to you this request. Do the right thing. I'll say it again. Do the right thing. Your decision to remand this case to ensure due process is met, to ensure my client has competent representation, and ensure that the decision is based on evidence, not false statements, would never be subject to any sort of legal challenge, never be subject to a valid appeal. But if you decide to do the wrong thing today, if you affirm a violation of due process rights, if you affirm a decision that is based on knowingly false statements, and if you affirm a decision where personal service wasn't effectuated, that is what appeals are made of. We shouldn't have to go down that road. We don't want to go down that road. And you can make the difference today by doing the right thing, remanding the matter for further proceedings due to the lack of personal service consistent with Arizona law and due process, and so that those rights can be met in a proceeding below. And I'm happy to address any questions that the board has.
Thank you very much. Very, very thorough presentation. Are there any questions at this time of the applicant? Anybody online that has a question from the board? I don't see Member Cardin or Ward. Any questions for either of you?
None from me, Chairman Loper. Thank you.
None for me.
All right, thank you. Are there questions of the applicant by anybody up here? All right, thank you very much. Hold tight, and if there's something else, we'll call you back up.
Thank you for your time.
What a show.
Right, this is different than other cases. It's not necessarily a public hearing, so we don't have to open it as a public hearing, do we? We do, okay. Open it as a public hearing. Does Is there anyone else who wishes to speak on this matter that's in attendance? Seeing none, is there anyone online who wishes to speak on this matter?
We're not aware of anyone online.
All right, I'll go ahead and close the public hearing. I have a couple of questions of staff. Darren or Wayne or whoever, the method of serving notice, was that consistent with county practices historically? Was that different or somehow out of?
Mr. Chairman, yes, it's consistent, and I believe council can speak to the issues raised by the appellant.
Mr. Chairman, members of the board, with your permission, I'd like to address the points that were raised.
Certainly.
Okay, first, let's give the overarching look at this. The respondent admitted that he was in violation of the zoning ordinance. That's in the very first paragraph of the compliance agreement upon which council seeks to rely so heavily. The statute says personal service. It does not say personal service in accordance with the rules of civil procedure. That's as compared to Title 48, 3615, which deals with hearings before the flood control district, where the statute says personal service in accordance with the rules of civil procedure. At the hearing and in your packet is an email from the manager of the respondent acknowledging receipt of the summons. That's what the hearing officer relied upon. Okay, as far as the no attorney, the ordinance requires that if you are to be represented, you provide 10 days notice before the hearing. 10 days before the hearing, we had notice he was being represented by an attorney. The night before, the attorney said, I'm not showing up. He had the right to have an attorney. He didn't show up with an attorney. As far as the failure to continue, a continuance is a request. It could have been made of the hearing officer. We would have opposed it because this has been going on since 2019. As far as proceeding without him, the ordinance specifically provides that if an applicant does not show up, the hearing may proceed in his absence. The applicant chose to excuse himself. The hearing officer was perfectly within his rights to continue once he decided to leave. As far as lack of evidence of his responsibility, once again, October 13th was when he said he's not representing. Sorry, apparently it wasn't the night before. I relied on what council had represented.
Mr. Peck, and what day was the hearing? Okay.
November 8th.
Okay, we did not receive a notice 10 days before that hearing that there was going to be representation. And under the ordinance, you can be represented by council or anyone. Okay, as far as lack of evidence, I remind you again, in the compliance agreement, he admitted the violation. Let's talk about the money, okay? What the compliance agreement said was there's $3,500 due. That was paid. All of the other money paid was in conjunction with the application for the rezoning. Inspection fees are doubled. Certain fees are doubled when there is a violation. So you understand, because the applicant doesn't seem to, all a compliance agreement says is you're in violation. If you do these certain things, we won't fine you for that violation, but you're still in violation. Applying for zoning does not magically convert a business in a residential zoning district into a permitted use. I think you all know that. As far as the trailer, the statement that trailers don't have to be permitted, you know, is not true. It depends on how you're using the trailer. Now, let's talk about, there was a representation that the issue of the nullity of the compliance agreement is properly before the court. I would disagree. The county has not been served in that case. Now, let's talk about the tabling and why it matters. It only matters because The applicant was so lax in his application to come into compliance. He applied for the rezoning 10 months after the compliance agreement, 1 month before it was going to expire. You all have experience with the county. You can't get a rezoning in a month. So he did not proceed diligently. The reason it was tabled was because the night before the hearing, there was new evidence presented, and the Planning and Zoning Commission felt they needed more time. I did tell them they could not continue without the applicant's consent because they were in the middle of the presentation. That's true. But a motion to table is always in order, and it stops any other proceeding. It's indefinite until a member of the commission says, I move to remove it from the table. No formal request has ever been made to the Planning and Zoning Commission to remove this item from the table. Now, as you know, you are a quasi-judicial body. Planning and Zoning Commission is not. It is a legislative body, and they can decide to do what they want as long as it's not arbitrary, capricious, or violating someone's rights. Tabling an application doesn't violate anyone's rights. The reason they're alleging it violates his rights is because now he can't meet the deadlines of the compliance agreement. But that deadline has been extended 3 times, and still they did not get an application before P&Z that they, in their legislative capacity, felt justified them making a decision on the merits. None of what they have alleged is right. None of it is a procedural error. And I certainly don't take a threat that we're going to go to court as anything that concerns me in a matter where the respondent has admitted violation. I'll be happy to answer any questions.
Member Person.
Mr. Peck, I have a question about the legal service. So is there a requirement that they have to notify you the 10 days prior? What happens if they don't notify you? A phone rings. What happens if they don't notify?
Yes, if they don't notify us, Greg's phone rings. What happens is when they show up, if they show up with counsel and we feel we haven't had time to prepare, then we will request a continuance. But here we were told there was counsel, and now there's no longer counsel. Clearly, in our mind, the respondent understood what the process was to get counsel. He shows up that day and says, I don't have a lawyer. Did not formally request a continuance.
Okay, so from your perspective, there's not, he had an opportunity to get new counsel and then alert you to that, and he didn't.
Yes, according to Darren, it was almost a month before the hearing that we were told he wasn't represented by counsel. I can only come to a presumption that counsel advised its client that I'm not representing you anymore.
Okay, thank you.
But again, even if an applicant doesn't show up, we are allowed to proceed. And Darren, if you ask him, can tell you that happens a lot.
Any other questions of Mr. Peck? Darren, you had something to state?
Just for the record, the applicants paid $10,000 in noncompliance fines and 2 payments based upon the compliance agreement. There have not been any daily noncompliance fines paid. When the last compliance deadline extended wasn't met, there was no noncompliance fine paid. There have been no daily noncompliance fines paid since then. The applicant has paid all zone change application fees, including the investigative fees, which apparently were paid in September of 2022. So there are no fees outstanding right now in regard to the zoning case, which isn't before you. There have been no fees, daily noncompliance fines paid in regard to the compliance agreement. That's been superseded by the hearing officer's judgment, which includes different fines that have not been paid to date.
Thank you. Member Cardin or Ward, do either of you have any questions of staff or anyone at this point? right,
not.
I will turn it over to board members for discussion and or a motion. And the motion is to either affirm the hearing officer's determination, remand it back to the hearing officer based on a procedural error, or continue it to another board meeting. Member Schwartz.
Yeah, just a quick comment. Based upon Mr. Callahan's presentation, you're very articulate. Thank you. But a light bulb went off in your presentation that triggered something that I think I hold very deep about what we do, not just here on the board, but what staff does on a day-to-day basis. I've been here in the Valley for 35 years. I've sat on a whole bunch of boards here at the county and served with staff in many different capacities. Staff's only motivation has ever been to serve the public. They don't have motivations to hurt people, to pull the rug out from underneath anybody. They're actually here as servants of the community. That's what they get paid to do, and that's what they do. And I'm very proud of what they do. And especially in today's climate of hearing all the things that are going on, you know, out, whether it be in the media or in the public, to hear somebody come in to this body and say there was a motivation to do something to somebody, it to me is very harmful and hurtful. I know personally from all the things that I've done with Mr. Gerard and others that they really care about the outcomes, positive outcomes to people. And I hope plenty of people are listening to this, that they understand when they come in here that, you know, what the goals and objectives are here at the county, at our boards, and at the staff level. I'm proud of what they do. I will continue to be proud of what they do. We all don't see through the same lens that sometimes we agree to disagree. But we don't use words like that to articulate the intent of people, because the intent here is good. And I will take that with me wherever I go. So thank you.
Thank you. And I would echo some of those same comments, if not all of them. My primary employment has been for the development community over the years. And although disagreed with stuff, I've never found anything to be malicious or meant to be against me. It's been a number of years, but I was unsuccessful with the hearing officer as well. But that has no bearing on this, other just a little history that I'm not leaning in favor of one over the other. But with that said, is there a motion to either affirm hearing officer determination, remand it back to the hearing officer for a procedural error or a continuance?
If I can make a motion.
Go right ahead.
Motion to affirm the hearing officer's findings.
We have a motion by Member Schwartz and a second by Member Person. Would you please process a roll call vote?
Member Cardin,
Yes.
Member Schwartz,
Yes.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's to affirm the hearing officer's determination by a vote of 5-0.
All right, we're going to move on to the regular agenda, BA 2022-056. Mr. Landis?
Morning, Chairman Loper and members of the board. Agenda item number 6 is for subject case BA 2022-056, which is a variance request for an R5 zone property located at 414 South 97th Place in the Golden Crest Terrace subdivision near Mesa in Supervisory District 2. Approving this request would have the effect of allowing for a 16-foot rear setback where 25 feet is the minimum permitted to allow for the building of a single-family residence. Next slide, please. The subject lot was created as part of the plat for the Golden Crest Terrace subdivision in 1968 and has maintained its original bounds since then. The lot meets or exceeds the standards for an R5 lot and is not encumbered by hillside or flood conditions. As part of the application, the applicant intends on abandoning the existing septic system on the south of the lot and relocating it more towards the northeast corner of the lot. Next slide, please. The site itself has been subject to several violations over the last 20 years, ranging from trash to occupied RVs, and the lot has generally been in a state of disrepair. The applicants, as part of their development of the parcel, had the existing structures demolished, and the lot is currently vacant, and there are no current active violations. Next slide, please. The applicant is requesting this variance due to what they consider to be the constrained nature of the lot, and that the nature and size of single-family residences has changed considerably since the subdivision was first platted in the late 60s. However, as the lot already meets the existing zoning ordinance requirements and is not of an obtuse shape or is otherwise encumbered by inclement site conditions, staff is recommending denial on BA 2022-056, as the applicant has failed to prove that there is a peculiar condition facing the property. However, if the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination with findings and conclusion in a motion to grant the relief sought. And at this time, I'm happy to answer any questions.
Great presentation, Mr. Landis. Is there any questions of staff at this time? All right, seeing none, I'm going to open the public hearing. Is the applicant or applicant's representative available? Come on up and provide your name for the record, please.
Sorry. Good morning. Can you hear me? Hi.
Please provide your name for the record.
My name is JD Woods. I am one of the co-founders of. Oh, sorry. No, keep talking. Oh, perfect. That's all I got from you.
Oh. I remember a presidential candidate who lost an election over an error with the podium.
Thank you. All right. Hi. So first of all, we did a PowerPoint presentation. Is it here? Is it available? Oh, okay. I'm sorry. So yeah, our client chose this home out of 6 or 7 different designs that we have. It's a standard design. We design net zero energy efficient homes, and this is one of the designs that they chose. They chose this because they didn't want to or could not afford to do something that was custom. So the wife and the husband loved this design, so we went with this for them. You'll see in the presentation that, do I just ask you to go to the next slide or? Okay. I think it's the next one, please. So you'll see we're already at 16 feet. You also see that the public utility easement is there depicted. You'll actually see red lines to show it more clearly. Our building structure is outside of the PUE. There is no conflicts with any excavation or digging for optics or phone lines or gas or anything like that. So we're simply asking, we're already at 16 feet. We're just asking for a 9-foot exception. If we can go to the next slide. And the next slide, please. So this is the area, obviously, of the community. What you'll find as we continue to go through this is that none of the units in this subdivision are conforming to the setbacks, and they'll be clearly shown as we continue to go through. And so once again, we're outside of the PUE, and we're outside of the any conflicts for digging or excavation. If you can go to the next slide, please. This is just some general information. If we can go to the next one. So here's our project site. It shows the building envelope here outlined. It shows clearly the PUE. It shows where we're starting. This is actually, I think this is addressing So we did have one person, I guess, that showed up to the hearing, the public hearing, and they stated, he gives his name, and he stated that there was going to be an issue with, let's see, I'd like to say that, again, this is against the variance because he talks about the alleyway and there being a conflict based on utilities. There absolutely is no conflict. As we go to the next slide, you'll see, actually, it's the final slide. Again, this is our building envelope, the floor plan layout. We can go to the next one. This is the design that they chose for this home. It is, once again, net zero. It's going to be solar panels on the roof, very energy efficient. We can go to the next slide, please. And the next one. And the next one, please. So there's our unit placed on the lot, 3D rendering. You can go to the next slide. This is showing the PUE from, oh geez, I forgot which direction this was facing. I forgot if it's north to south, or east or west. But anyway, we're showing the PUE along the length of this parcel. As you can see, there's homes currently are in the PUE, including the neighbor who opposed us getting this variance today. His home is actually in the PUE and not conforming to the setbacks either. You can go to the next slide, please. The next one. This just shows the building envelope. The next slide, please. And then this, again, you'll see this is supposed to be the boundaries for the setbacks. You can clearly see along this entire community, like all of these homes are within it. Ours is clearly outside of it, not in the PUE, no obstruction, no issues with excavation. If you can go to the next one. And the next one. Once again, we're just showing our unit. You can go to the next slide. And we're showing, once again, other properties that are clearly within the setbacks. You can go to the next slide, please. And this is showing the public utility easement, the west side rear property line, the south left. You'll see our building envelope again. The next slide, please. The house, which is outside of it. Next slide, please. And so we ordered a blue stake. We call it Arizona 811. And you'll see, we had a hard time with the pictures, like showing the actual markings on the ground. So we kind of just marked it in yellow. But you'll see with the building, the PUE, the setbacks and all that good stuff, we're outside of it. And there's no, you'll see the actual report. It's the second to last slide showing that there's no excavation conflicts. And then we again show that we're outside of the PUE and we're simply just 9 feet out of compliance with the setback. You can go to the next slide. Again, just showing the building and the way it's going to sit. Excuse me. The next slide, please. You can actually see that the neighbor actually is on the property line of our client, but we just wanted to show that. The next slide, please. And the next. And the next one. Next slide. I'm not sure whether this is all general information. Next slide, please. And it just basically showing, so these slides is what we're showing is that we're showing that the Arizona blue stake clearly marked and that we're outside of it and there's no excavation conflicts, and it's showing that there's no conflicts. So that's what those slides were, sorry. So this is our summary, projects to enhance the community. This would be a 2023 build. We're building these net zero homes throughout the valley. We're obviously acknowledging the housing crisis here in Arizona. The client loves this home. They were approved for this. It was a more affordable option for them. So starting over for them is going to be a really big challenge because of the time it takes to get these things through permit. And we have well planned for residents, healthy, peaceful, comfortable, which obviously that's what we hope to achieve with these net zero homes. If you can go to the next slide, I think this is the last one. Is this the last one? Okay. So that's all. We're simply asking for just a 9-foot exception to the setback. We wanted to show today there was no conflicts with where the actual building envelope is. There's no excavation conflict. There's no issues with us digging down to the that will affect the utilities, like the neighbor has stated in his opposition in the public hearing. And we just want to ask for a 9-foot exception so we can build this home for the client and not have to start over. So that's all I have.
Thank you. Very thorough presentation. I see that a couple people have questions. Member Person?
Thank you. Thanks for your presentation. The home looks beautiful.
Appreciate that.
You mentioned that there were 5 or 6 different options that your client could have chosen from. Are there any of those options that would not violate the setback and require the variance?
Not for the size that they need for their, I'm sorry, not for the size that they need for his family. They chose this option because it was the better one. The other ones were around 1,100, 1,300 square feet. He has a pretty big family, so this was the most cost-effective option for him that would actually fit his family's needs for rooms and square footage.
Thank you.
You're welcome.
So my question is to staff first, but I want to talk to you about it. So is there something in the R5 district on if it's a side loading garage, if there's a reduced front yard setback?
Mr. Chairman, board members, there is not in straight zoning districts. That has been added often under a RUPD overlay. And it's pretty routine under an RUPD overlay to have a different setback for front facing garage than for the forward living areas and side loaded garages. But our zoning ordinance is very straightforward, and the front setback is I believe 20 feet for all the residential zoning districts.
Okay, so the next question is typically what do you see for front setbacks on side loading garages? Just a kind of a range.
10 foot, we have under the RUPD seen 10-foot setbacks.
10-foot setback.
But that has to be, that's only, that's not normal under a straight zoning district. It's when there is a rezone that applies a RUPD overlay zone.
Okay, and have you ever seen that done on one home site before, that process?
No, not an RUPD overlay. We would not, staff would not support a residential spot zone. There may have been, I don't know of any variances in the past. I can't speak to that, and I apologize.
So there's no administrative or legislative act that he could obtain if he wanted to put a side loading garage on here to help mitigate the issue of having to go up to a variance? That's the point, is it not trying to completely redesign the house, but give him, because I know like my house, I needed more house and I needed to conform to certain setbacks. And so I put a side loading garage in, I moved the house forward towards the street, and it worked.
There's no, Mr. Chairman, Member Schwartz, there's no administrative process. Legislatively, they could seek to organize the neighborhood for a rezone. They could seek a rezone. We wouldn't support it without other properties, unless it was a boundary smoothing issue. They could seek a change to the zoning ordinance, a text amendment, and then it would apply across the board to everybody in the same zoning district or as a general regulation.
Right.
But I'm not aware of an administrative process.
Okay, all right. So my point of asking him was to try to give you some options for your client without having to go back and retool an entire house, because I understand the needs of the space. We have 3 categories that we have to apply towards a variance, and I'm having a hard time finding that, but I want to try to help. And so I don't know if anybody has any other thing to add, but I'd almost ask you to go back to your client and see if they can maybe go upstairs and reduce that, so that I think that it's, there's not a peculiar condition here that exists that I can see, but want to hear from everybody else.
I do have a question for you. So looking at the area where you see most of the other lots and the other parcels in the community is platted, but they're non-conforming. Is there any exception that you're willing to make, or to look at the fact that this entire community is not conforming to the setbacks?
We can only discuss what is in front of us today. The fact that
enough.
they're in non-conformance, that's up to the county staff to go out and determine. It appears, though, from the aerial that most of those homes out there are trailer homes. They're mobile homes. And so I don't know if they are in conformance or not in conformance until somebody brings something in front of us to tell us that's the case. But we can only act on what's in front of us today, which is yours.
Fair enough.
Thank you, Member Schwartz. Member Person, did you have another question? Member Cardin.
Question for the applicant. Just curious if you've had any discussions or if your client has had any discussions with the neighbor that is in opposition.
No, we made an effort to reach out, but based on his letter, it was discussing a conflict of us excavating down and it being a conflict for his utilities. But then when we actually did the Arizona 811, it's unfounded. Like there's no conflict for excavation. It's not going to affect any of the utilities or anything like that, which I have in my slides. So he never returned our call or our emails. And since there was no conflict, we never pursued it beyond that.
Thank you.
You're welcome.
I do have a question of the applicant. Early on in Mr. Landis's presentation, it was mentioned that the septic system, which is in the lower right-hand, or I'm sorry, the lower right-hand corner of the property, is being relocated towards the northeast or the upper right-hand corner, if you will, of the property. It was in one of the if somebody could pull up the site plan itself. Well, I went on the screen, but is that accurate? Where the septic go? Is it possible to get to the site plan? There you go. Well, yeah. So the overlay on the aerial shows a septic system and leach field, and that's going to be relocated towards the rear of the property.
I'm not certain. I believe so. Where are you seeing that?
So this site plan is oriented so that east is facing north. So the current septic system's on the south of the property, south central. Their plans indicate they intend on moving to the northeast corner of the property towards the front.
Okay. So we get in discussion a lot about the impact of septic system and leach field. And certainly to me, that kind of dictates the home that can be placed on there until the county changes, or I guess environmental laws change generally. And I'm not in support of this, but you can't put a house on top of a septic system or the alternate field for that matter. So to me, because I like where Member Schwartz was going, but then I think, well, you can't really go wider. And we've had this discussion on other ones before, going up. Not everybody likes the stairs, especially me as I get older. So I'm in support of this based on leach field, septic impacts. I like that you made an allowance for the PUE.
Thank you.
That email mentioned about it being an alley, but it doesn't look like it's a functional alley for people to drive up and down.
No.
But you would be wise to try to stay out of it in case they ever tried to come through and just replace the underground utility lines. All right, you would hang tight and
Yes,
we'll see if there's any other questions for you. So I mentioned that it is a public hearing and we'll proceed first with those that are in person today. Is there anyone who wants to speak on this particular case that's in the audience? All right, seeing none, is there anyone registered online?
We're not aware of anyone online.
Okay, we'll go ahead and close the public hearing and turn it over to board members for discussion and or motion. I forget which district this is in. Yeah, go right ahead.
I'm always mindful of trying to help people out, but in this case, somebody's function of their house, how they want it laid out, is not a peculiar condition. It's subjectively on how they'd like to live. And there are plenty of other floor plans and house styles that could fit on this size lot other than what the applicant's proposing. So as much as I'm sympathetic, to to their wishes, our decisions are not subjective, they're objective to being a peculiar condition. So I'm not going to support this, although I'd like to try to help. I don't think that this is the proper place for that to occur. It's with an architect and both of us, Greg, have been in the building. We all have been in the building business and seen various, size houses, from wider houses and more shallow houses to be able to fit, these typical lot sizes.
Yeah.
Making a motion?
Well, I would just want to see I can make a motion, but I wanted, if anybody else has any comments before I make a motion.
Member Person and then Member Cardon.
Yeah, I appreciate the beautiful design and obvious intent to do something, I don't know where, oh, there he was, sorry, better for the neighborhood, but I have the same challenge that we're obligated to look for a peculiar condition to approve these types of things, and I'm not seeing one here. I do think there could be some other options with a 2-story house, or perhaps if there were ability to separate the garage and move the house forward. And I'm not meaning to cause a bunch of extra work and cost. I just am not seeing the peculiar condition here. So I won't be able to support it.
Member Cardon.
Chairman Loper, thank you. And actually, I have to say, Member Schwartz and Member Person make good arguments. And frankly, I'll admit that I am straining when I say what I'm about to say, even reaching probably out of reach. But if there were any peculiar condition, it might be kind of as stated by the applicant, that this lot was created in 1969, and in general, building plans have changed. And again, I'll readily admit on the record that I'm reaching pretty far here to try and find a peculiar condition, because I think Member Schwartz and Member Person make great points. So in general, that would be the reason I would be in support.
All right. Any other comments from any board members? Seeing none, I'll entertain a motion.
So I'd like to make a motion that we deny case BA 2022056 because it doesn't meet the statutory test of variance approval.
We have a motion for denial by Member Schwartz. Is there a second?
I'll second.
Second by Member Person. Rosalie, if you please do roll call.
Member Cardon.
No.
Member Schwartz.
Yes.
Member Ward.
Yes.
Vice Chairperson.
Yes.
Chairman Loper.
No.
Chairman, that's a denial by a vote of 3-2.
That variance has been denied. Wish the best to you and the property owner on working on an alternative design as best you can. Thank you. Sorry. Next item on the agenda, item number 7, BA 2022-059, the Blackman property. Mr. Mueller, if you would go ahead with the presentation.
Thank you, Chairman and members of the board. Case BA 2022-059 is for the Blackman property in Supervisor District 3. The site is located at 46236 North 38th Avenue in the New River area in the Rural 43 zoning district. Next slide, please. The request includes the following. A proposed lot width of 120 feet where 145 feet is the minimum required. And additionally, proposed hillside disturbance of 3,800 square feet and location of septic outside of the lot's principal building envelope where no disturbance is allowed. Next slide, please. The request would allow a single family residence to be permitted on site. Staff notes that no permits for a residence have been submitted at this time. Staff has received 3 emails of opposition on the case. Next slide, please. The applicant has failed to demonstrate that there is a peculiar condition facing the property because the substandard lot width was the result of unregulated land division, which should have been considered during the creation of the parcel. Additionally, the proposed hillside disturbance is to facilitate the septic location. Since no building permit has yet been submitted, staff feels that alternate locations or options for the septic have not yet been exhaustively explored, and that there is potential for a residence and all septic and grading to be located within the principal building envelope. The applicant has not demonstrated applying the requirements of the MCZO to this property that has these particular conditions, and undue physical hardship exists because the slopes present on this property are prevalent throughout the neighboring properties. If the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination with findings and conclusion with the motion to grant the relief sought. In such event, staff would offer the board with the following to memorialize approval. Variance approval establishes a 120-foot lot width and APN 202-13056D. Variance approval allows up to 3,800 square feet of hillside disturbance outside of the principal building envelope and APN 202-13056D. At this time, I would be happy to answer any questions you may have.
Thank you, Joe. Mr. Mueller, good presentation. Are there any questions of staff at this time? Just one from me. You'd mentioned earlier on the presentation that, could you go back to the topographic map, please? So based on this, you believe that they could actually meet the building or they can meet the zoning ordinance requirements by moving the home and the septic area to the south? Because in this instance, the septic, the leach field and the backup leach field, they both apply towards the disturbance.
Chairman, that I am unsure if that would be an option, but staff feels that that option has not been explored. And if you look at that grading map up on the presentation there, there's a green line that shows approximately the principal building envelope. Is showing somewhat inaccurate as to what the principal building envelope actually is. That envelope does actually extend all the way down south up to the front yard setback, which should be 40 feet from the patent easement on the south there. So
Okay.
There's more room than what it would initially appear.
They may be taking into allowance the areas in blue. That's drainage, my guess. All right, thank you. Any other questions of staff at this time? All right, go ahead and open a public hearing. Is the applicant or applicant representative here? You could come up and provide your name, please, and then proceed with your presentation.
I'm too short. I'm not going to touch it. I'm not going to touch it. My name is Samuel Blackman, and thank you, Mr. Chairman, board members. Good to meet you, Joseph. I would also like to thank my neighbors for showing up. It's good that they're here. My first slide is about drainage. It's one of the issues that they presented. I want to say that this is kind of not my design. It was designed by a civil engineer. An engineer went out and looked at the property, said that drainage is not going to be an issue. I think that the planning department also said that drainage is not going to be an issue. We've got the wash to the west and that ridge to the east, and it's going to solve all of the drainage problems that my neighbors might have come up with. Next slide, please. This is my main issue, the width. The width is a problem for me because we're measuring it at its narrowest as opposed to where it is actually 145 feet wide. The purpose of this statute was to basically have orderly growth and sustainable development. And I feel that when I did do the abandonment of that northern easement, we're able to move the property further north. And get behind that 145-degree width line. So if we would measure at that line as opposed to further south, which, I agree with RU 43 when it says, we need sustainable growth in this area. We don't need to put houses right next to each other. So that kind of triangle shape that's been built because I was able to move it further north does that. It falls in line with sustainable development. And it kind of offsets that buildable area. One of the things that I read that staff wrote was that the parcel was created by an unregulated splitting practice. I find that completely irrelevant because it is 145 degrees wide right there. And also I cannot purchase land from either side or either parcel on either side because there is a clean out for a leach field on the west side, and there is also a gas tank with plumbing going on the west side. So purchasing land on either side is not going to be possible. So it has that peculiar condition where all I'm able to do is to go behind that line, and that's why I abandoned that northern easement. Next slide, please. So the hillside variance was something that was kind of an afterthought after I requested variance. I thought, oh, okay, width is my main issue, but hillside is subject to hillside. That is a typo. It's 17 to 11%, but right there where we're building the property, it needs to fall into, all disturbance must be located within the buildable area. And it's not. That leach field is the only thing, and that septic is the only thing outside of that buildable area and that bottom green dotted line, that's where it is 145-degree width. So I kind of drew this funny shape so that we would know the buildable area. The residence itself, the structure is only 3% of the entire lot, and the disturbance will be 10%. So it's going to do what the purpose of this hillside law is, which is to preserve the natural topographic features of the land. And the house itself is only going to go up, or I'm going to cut 4 feet. So it's actually the least sloped part of the entire lot. And that's what I wanted to say. For hillside, it goes down to what I calculated out to be 11% right there because the lines are much closer together right there. So it's actually the only spot that I would actually want to put a house because the rest of the lot does have more of a slope. So that would cut costs, and it would also preserve the natural topographic features. That's all I've got.
Thank you. Are there questions of the applicant? Member Person?
Yes.
Hi there.
Hey.
A few questions. What is the purpose of the yellow lines on this diagram?
That's where the photograph is taken in the upper right. You can't see my car. In one of the previous photographs, you can see the car, but you can kind of see naturally that there's a very flat area right there where I plan to build. And so the slope is much less. And so I put that on my hillside slide.
Okay, thank you. And then my second question is, am I correct in restating that you chose the location of the septic tank and the leach field because you're less of a cut, but it's not possible to put them within the buildable area?
It is possible. And this is something, like I said, my engineer came up with this. And so he was saying that we could put the leach field there. It's actually ideal because of the slope. But if I could get variance on the width, then I can just say, this is now the buildable area. Let's move the leach field into that, and then we don't need to worry about hillside. But I'm not married to this design. What I really need is the width to be. That's my main purpose of what I'm trying to get.
Would be willing to find a different design for those two and perhaps
Absolutely.
that
And
specific variant.
that's why I didn't draw any plans for the actual house. All I'm trying to do is get that width established so that I can get a buildable area established, and then the house can go and we can move the leach field into that.
Thank you. And then, sorry, I have one more question. We do have one email that was submitted with an objection to the variance, and they talk about that they oppose this because they understand you're trying to seek a variance to put utilities across their property and that you have 0 lot lines. And I'm not seeing either of those things, so I just wanted to make sure I wasn't misunderstanding.
No, there'll be no utilities across. They'll follow the, I don't know if there's a slide we can go back to, but the driveway goes straight down to the street, 38th Avenue.
Mm-hmm.
And so that's where water would be and electric. So it would not cross lot lines.
Okay.
I think the main issue is that plumbing to the to my east, there's a propane tank, and I'm not gonna, that's why I want the buildable area to be further north. I don't want to build so close to my neighbors.
Thank you, appreciate that.
All right.
Thank you. Member Schwartz?
Yes. So can we pull up the excerpt from the proposed site plan?
The one that was this one?
Yeah.
Okay.
Yep. Yeah, that one.
Yeah.
So a couple questions.
Mhm.
Have you, is the building envelope accurate as noted here? And the reason I say that is because the entire driveway is outside the building envelope as it's depicted. And typically when we create building envelopes, it includes the pathway to get up to the buildable area.
So that line going south, that's the
Yeah.
driveway.
Yes.
And so we're considering that part, we're gonna have to excavate it or build the driveway.
But is it part of the building envelope?
You mean part of the structure? Maybe I'm confused by that.
Mr. Chairman, board members, I believe what you're getting at is the building envelope formed by the setback lines where they possibly could build and disturb. And that's not accurate. It actually would be 40 feet off the street line on the south.
Well, no, not that's what I was getting at. What I was getting at was, the amount of, is that being equated as part of the disturbed area or not, the driveway?
Okay, I believe it is.
Okay, so there's two pieces of disturbed area, the one where the leach field's at and the second area is the driveway.
And I apologize, but the driveway disturbance outside of the principal building envelope is permitted in the hillside.
It is, okay, that's what I wanted to make sure. Okay, so here's where I think there might be a peculiar condition, but I'm not sure you'll have the answer for us today, okay? And that is that sometimes I've seen where we had these odd shaped lots and we took the principal width and then basically the carve outside, we took that carve outside and did an average. So we could see what the average width of that was to see how that impacted that 140 feet that's required. So I like the idea of moving the leach field, okay?
Okay.
Now that I understand the driveway's not an issue, but I think that before I can make a decision to give you a variance, okay? I want to know what the distance of that is and come up with an average number.
Right.
Because I think that that it wouldn't be precedent setting on what you're asking for, if that makes sense.
Okay, so I don't have an answer for you,
I know
you
that.
said.
But I would consider giving you some time to come back and talk to us about that because that becomes could be considered a peculiar condition. So, okay, that's just my comments and feelings.
Thank you, Member Schwartz. Any other board member have a question at this time? I have a question of staff. The 145 feet that's required for lot width in Rule 43, that's measured at the setback line, which is 40 feet from the back of the property line on the south, correct? So it's by definition, so it's the way it's defined in the ordinance. Even if we had, an average would be informational, but average doesn't help him from the ordinance standpoint because the ordinance requires that it be measured at the setback line, correct?
Chairman, that is correct.
Okay. All right. Hang tight. If there are any other questions, or do you have another one?
Well, I'm
Member Purcell,
having
go
a hard time. I am wearing my glasses. I'm still having a hard time reading some of these numbers, but by my calculation, I do think that if they calculated it by an average, it would well exceed the 145.
So, Mr. Chairman, just to make sure everybody's on the same page, and correct me if I go off, the variance is the pink disturbance along the right-hand side of the exhibit, which is the disturbance inside their disturbance footprint inside the side setback. So it's outside the principal building envelope. And the hillside ordinance is really just protecting the perimeters of lots, right? And so it's only I don't know if it's really shown well, but you can see where that triangle of pink is. It's that area along the right. It's not,
I think that we're talking about is the width of the lot at this point, not the area outside of it. Because I think he said that he could move all that to get rid of it, but we're trying to figure out the width issue and how that impacts the ordinance.
But the ordinance, I'm wanting to make sure or confirm, the ordinance doesn't talk about average lot width. The ordinance just says the lot width at the setback, which that's not, I mean, I don't know how deep that is till it takes its angle.
Mr. Chairman, that's correct. The only place to measure lot width per the ordinance, the official definition of lot width, is at the front setback line.
Right.
So assuming there's a 30-foot easement, that's a street line, you would measure like 70 feet from the property line or 40 feet back from the street line. And that's where you measure lot width. And they're 120 feet, and they're 120 feet for quite a ways until you get back to that northern triangle.
Okay.
So obviously, when somebody did an unregulated land division, a lot split, they put that arm on there to meet the lot area, but they didn't come up with the lot width.
Lot width.
Staff does, I'm not sure if there's ability to obtain land to the east and have that lot also meet lot width and setbacks.
Yeah, thank you. So knowing the average lot width would be informational, but it wouldn't change staff's position because the definition is width measured at the setback. So although I appreciate it, what you're both asking for, I just want to make sure that even if the average width comes back at 300 feet, he would still require the variance for lot width because of his definition.
Yeah, I'm not suggesting that he would need the variance. I just
Okay.
think that
I just wanted to know.
I just wanted to know because I think that because it's an odd forming lot and because it's pushed so far off the street that it creates this peculiar condition. And so that's what I'm trying to get I'm trying to find a way for him to succeed. So that's why.
All right, thank you. No other questions of the applicant at this point. If you hold tight, as I mentioned, I opened the public hearing. I do have a speaker card from John Dixon, who would like to speak on this item and is opposed.
Yes, my name is John Dixon. I'm on the parcel 056A. That's the one to the left or to the east. Left depends on where you're standing. I've noticed over the 22 years, I've noticed a lot of variances of people constructing, but I'm only addressing the ones that affect me personally. One was a septic tank. There was a direct burial septic tank sitting up above ground, and that house sold 3 times with a permit. A septic system that was leaking a quarter mile away, and all the drainage was in the parking lot 25 feet from the well. I discussed all of that with the planner, but I'm not here to discuss that. On this piece of property, I noticed that I was here several months back. There was a variance or to have the patent easement removed. That indicated to me that the house is going to be pushed up north, higher on the property. My concern is I have not seen a drainage and grading plan. I do not want any of that water shedding on my property because it'll come right down to my house. That's my biggest concern of this whole ordeal. If that property, that home was built parallel with all the other houses and stuff, not a problem. You can build it on stilts, you can put it in a conics box. This is New River. But if it drains on my property, that's an issue that I have. My question to the county is that I discussed this over 10 years ago with the county. I tried to get a hold of the county about that parcel being divided up that way. And the only reason is because the existing property owner couldn't make that 1 acre with the 120 foot. So he had to take a little piece of that above the adjacent or the one he owned. Nevertheless, it's still only 120 feet. And the statutes there, the R43 specifically says shall meet the 145 feet. Doesn't say you can or may or should. It says shall. And when I built my house, I had to make all those shall attributes come to life. My concern is that we keep allowing these changes. One, the patent easement, That's fine. I don't see utilities going up there. Now we're going to allow this width. How did we get here? My question to you guys is, who can I talk to be more proactive than we are sitting in here trying to be reactive? Is there somebody in the county that I can discuss with? Because I see this happening over the 20-some years that affects me personally, whether it's in wells or septic systems. Who in the county can I contact to be more proactive so that these things don't happen?
I'll take an attempt to address that. The county does not have a minor land division ordinance. And as Mr. Peck would attest, by statute, we can't have one that regulates lot splits. So when people do lot splits, they're technically supposed to meet zoning ordinance requirements, lot width, lot area, all the other requirements of a given zoning district. But there's not a mechanism in place for the county to verify that, other than somebody coming down here and asking informally, hey, what do you think of this arrangement that I'm going to go out and create to do this? That's the first part. The second one is that you're right, 145 feet is the minimum, but the variance process, that's why it's in place throughout the state, and I imagine other states as well, to give people an opportunity to say, I can't make that work in this instance. And then it's up to us to judge whether or not, judge may be a wrong word, but to decide whether or not the hardships as presented warrant granting the variance or not. And so this process that you're here for is the correct process to see if it can work around. If you wanted to speak further to anybody in planning department, any of the persons in front of me here could help you address that specific question, but there unfortunately is not a way to address minor land division.
Yeah.
Oh.
My attempt was, I told the existing property owner, because he asked me, do you want to buy it? I said, sure, I'll give you $2,000. The taxes, because you can't build on it. Oh, you can tuck a house up there. I told the realtor the same thing, and they just ignored me. Why? Because they already knew the problems with the property, yet they found somebody that would purchase it. So here we are, having to have this variance because it doesn't meet the requirements. How did we get here? That's where I'm getting at. Is
we definitely sympathize and empathize with you. The bulk of our variance items on a given agenda deal with this, lot splits, minor land divisions that don't meet ordinance requirements. There is a question by another board member. Go ahead, Member Schwartz.
So on the picture up here,
I don't see a PE stamp on that either.
Yeah, no, I know. But just, can you show me which house is yours? It's to the left or the right?
Well, mine is to the right-hand side.
Okay, all right. So I would agree with you. There is no PE stamp on here because he hasn't gotten to that.
Right.
Right. So what he was trying to do is not put the cart, I'm just making an assumption, try not to put the cart before the horse. They didn't want to spend a bunch of money on physical engineering for it until he knew what he could do. So I commend him for asking permission and not for forgetting us, not getting on the tips of his skis, right? But I do know, and Darren, correct me if I'm wrong, when you go through a design process, you have to, of a house, the engineer is going to submit a G&D plan. He's going to make sure that none of that water goes in to their property, and that where the septic system's at isn't going to leach onto somebody else's property, et cetera, correct? And is there a process by which the neighboring property owner could be notified of that, or it's just good neighbor being good neighbors, showing everybody to buy into what's going on?
Mr. Chairman, Member Schwartz, there is not a there's not a public notice or public input process on construction permits. They're ministerial, they're administrative, so it's a good neighbor issue. However, an engineered grading and drainage plan is required for all hillside lots. There's a drainage clearance on all construction permits for single-family residences. The purpose of the drainage clearance is to ensure that historic drainage is maintained or improved in the post-development scenario. So there will not be an adverse impact post-construction. It'll either be the same condition or an improved condition.
Okay, so my next question, are you an engineer by chance? Yeah, you are. That's okay, it's good. Um,
I don't have a degree.
But you understand these things, so that's good. So on the setback issue or the width issue, could the width be extended by an easement by a property owner adjacent to that gave them an easement for so many feet from the setback line or so many feet from the street or whatever you want to measure it to make that 140 feet work?
Mr. Chairman and board members, there are some administrative items, for lack of a more technical term, that can be kind of funky when it comes to unregulated land divisions. They can add easement width, depth, so that the street line goes much further into the property, and the setback line is measured further north. That area inside the easement counts as part of the lot area. It changes where the lot width measurement would be.
Right.
It would encumber the lot's buildable area.
And would there be a problem if there was language in an easement that said this was for the purpose of X and not for the purpose of driving over?
It needs to be an access easement.
Yeah, I understand easement, access easement, but not for you can say an access easement, but not for a driveway, correct?
I don't believe we could have a language like that.
Okay, all right. So here's where I always try to say, let's turn lemons into lemonade, and let's not look backwards. Let's look forward. The backwards gives us historical, but how do we fix things? And so I know we're still open for public comment, but I think that there's a solution here without having to ask us for a peculiar condition. And I think that if you spend some time with this nice fellow over here, that you might be able to accommodate his concerns and issues about where the septic system is, where the drainage issue, how you're going to solve the drainage issue, and do some sort of trading of a small easement to get you what you need. And I would highly suggest you make a good friend with him and with staff, and you guys can come to a meaningful, positive solution. That's just my opinion.
Thank you. There actually is a grading and drainage plan that was submitted with this. If you could go to the slide that shows topo and the drainage arrows. It was one of the handouts in the packet. Yeah, here. So for Mr. Dixon, you can see the blue lines. That's existing, follows the topography of the lot. You're to the right of that, but that looks like the existing and proposed drainage, which in my mind is a hardship they have to design around, doesn't seem to send anything to your side of the property.
Yeah, I see the blue line there, and it goes right against the edge of that piece of property. So I guess he's going to build right in the wash. That's not going to happen. There's going to be a cut and fill. We understand that part. I don't know what the contour lines are. If they're 10 foot or they're 1 foot increments.
Yeah, and again, it's a generalization. So whether it's 1 foot or 20 feet, it's still the blue line follows the convergence of those lines. And then there is a portion on the far east where it's going to be disturbed, but has to be restored, as Mr. Gerard stated, to maintain those historic flows. I didn't know if you had seen this, but there is actually a grading and drainage plan. Maybe staff could give you a copy of it.
Just my last discussion with the planner, that nothing had been issued. So, but that was several months back, or a couple of months.
There's actually a stamped grading and drainage plan. It's in your packet. If you wanted to, after the hearing's over, you probably could get a copy of this from staff. It is stamped. No worries. All right, any other questions of the speaker at this time?
No, as you can tell, my big concerns is how the county has been allowing a lot of these things we're into this reactive mode. we don't need to be there. I'd say we need to be in a proactive mode. Especially when I found that septic system, direct burial septic system, sitting on top of the ground. That permit was issued, that permit was accepted, people moved in, sold 3 times. That's when I had to call the county.
Again, we sympathize and empathize with you and feel your pain. And if you have more questions, certainly talk to any of these folks after the entire hearing's over.
Okay.
Thank you. All right. Is there anyone else in the audience? Do you have a question?
No, you can.
Is there anyone else in the audience who wishes to speak? If you could, number one, after you speak, fill out one of these cards to give to Rosalie. And then number 2, just provide your name for the record, please. And come up to the microphone.
My name is Viorel Di Siorba. And my land is 4 acres. We start somewhere in his arrow, the green thing, you know, in this area. Here, and I don't want all those. I have the land for over 18 years, probably 20. And I have the plan here, 145 for build a house there. And no disturbance of the land. This is why I got answer here probably 15 years ago. And you know, he put so much red in my blueprints where I'm going, make a professional. I have it here. So I'm drilling water. There's not too much water, and I'm in the bottom of the, very close here. This area here, here is my farm. He coming people for testing the soil for leach field. If I'm start to build, he say the percolation is very bad. So it's so many things, you know, what stop me. I even buy the plan for it cost me $20,000 for drilling 650 feet or whatever, and it's 1 gallon the water. He told me I need the retaining wall. I need so many things. I'm stopped to build, and I'm still on the land because everybody go, you know, it's so much regulation in those time and affect. And it's mine is larger, 145 feet, larger, 145 by 145. It's very long. The first one is the top, and another one. I'm not for, you know, I'm against, trust me.
A question of, go ahead, Member Purcell.
Thanks for your comments.
Thank you very much.
To clarify, are you, well, there will be that process that if this variance is approved, the applicant will have to go through that process, and they may get a bunch of red on their plans
I'm
too.
planning, you know, I buy even the plan for construction. I'm split I'm combine the land pay for combine. After those, I'm split again for give me those. It's a so build side the hill, you know, it's very complicated. One, the second one, no disturbance the land. You don't. I have a 0.2%. It's not 1%. I have disturbance. So I'm go back with a plan and mirror imagine, or you know, to have the bottom of the house with the top of the roof for B, because I want to build 2 level. So if he be below 30 feet. And everything costs money. In final, you know, it's very hard to do, you know, and everybody need to understand when you buy something, you buy and say, oh, I buy gold. It's just plating gold. It looks good, you know, and those road, you know, the guys with the pit, the neighbor destroy all and everything, you know, it's outrageous, you know.
Yes, thank you for your comments. I'd encourage you, if you have a question, because regulations change over time, to maybe meet with someone here in the planning department after the hearing. to discuss any specific issues about what maybe there's some positive changes for you.
One more thing, he being he not being the joke. The guys, I say, hey, how I have to make this help me? Or you need to find the architect. You have to find this. And he say, you guys don't understand. You're coming all over the world and you want to build mansion in the top of the hill. No, I just want to build how much, 3,200 square feet, how much supposed to be in, you know what I mean? And he say, yeah, but because you guys make those regulation and stop us, everybody built chicken cage in the top of the hill. You know what I mean? So, thank you. I appreciate it.
Yeah, no, sir. Appreciate your concerns. I would suggest you reach out to Darren and show him your plans, show him some of your things that you've had with problems with over the years, and he might have some good ideas because he's a problem solver. Okay? And thank you for coming today. Really appreciate it. God bless you.
Thank you. Is there anyone else in the audience who wishes to speak? I'll get back to the applicant in a moment. Yes, if you could come up and provide your name, and then also please fill out a speaker card. And if there's anyone else who wants to speak on this or another case, please fill out a speaker information card prior to coming up, and that way I'll be able to call you in the correct order and everything. Go ahead with your name, please.
I'm Lucy Mitchell. I'm the property just to the west of theirs. My concern is, okay, so this gets approved because things get approved, whatever. And he goes through different hoops and whatnot. What happens and what recourse do we have when his septic systems are coming onto our properties, when his leach lines are flowing down onto us, when he needs to put in a well and he's disturbing some other thing and it adversely directly affects us? At what point do we say, you guys, I'll let this pass. We told you these things were going to be happening. When do we get to have basically a say of this is going to be too much for us?
There is a department here at the county, Maricopa County Environmental Services Department, which regulates septic systems. Again, if you talk one of the persons up here, they can get you at least the contact info. They're not represented here today on this particular issue, but then you could talk to them about how they're regulated and permitted and how you do complaints. Wells are strictly through the Department of Environmental Quality. I'm sorry, not Environmental Quality, Department of Water Resources. There's some minor involvement by environmental services with the county, the one I just mentioned for septics, but really it's a state agency when wells are permitted and then drilled and become operational. I hope that helps.
Does he have to have all that? I mean, I guess, yes, he has to have it permitted, but do we get a say of, okay, this is going to directly affect our property when you decide to drill a well?
Unfortunately, as mentioned by Mr. Gerard a few minutes ago, there's not a process whereby neighbors get notified when another neighbor is developing their property. It tends to be, it just is what it is, more of a complaint basis if something goes wrong. But I would encourage you to talk to, again, environmental services about the septic, and then to some extent the water well, and then Arizona Department of Water Resources regarding a well. I can tell you that septic systems have evolved a lot over time, and you could pretty much make a septic system work on concrete or paving. That's not what's happening here, but there's a lot of evolutions in engineered systems. Again, talk to planning and try and get those contacts that can get you people that are way smarter than I am and know a lot more that can help you with that. And Mr. Schwartz, or Member Schwartz.
Yeah. The well issue, when you reach out to the department, they'll talk to you about drawdown. They have requirements on where you can place it and how it can't affect the other wells in the area. Basically, they have what they call drawdown requirements. And so to get that permitted, he's got to have an engineer approve that it won't be any other impacts to the neighboring properties. So rest assured, there's a lot of checks and balances in place for you, but nonetheless, if you reach out to the agencies the chairman talked about, they'll be able to guide you through that and help you. Okay?
Okay, and one more, with that wash that goes there, I know it looks like it's not a big deal, but say we get a good rain monsoon, our septic and leach lines are right there up against, so if he diverts it even just a little bit, it's going to back up our leach lines and it's going to cause problems for our septic system. I don't know if they looked into that when they looked into, okay, it's not going to be that big of a deal, but if you're putting a road in and having to build it a certain way, it will most likely push the water this direction, which is going to go directly into our leach lines. So it's just, it gets to a point where we don't know about it until after the fact, and then we're putting thousands of dollars of bills to trying to get our stuff taken care of. That's my big concern. So, and we haven't gotten any information. He hasn't talked to any of, he's not talked to us about any of his plans, nothing. There's not been any communication to try to be like, hey, neighbors, what can we do to make this work? Nothing. So that's my big concern. Any other questions?
Thank you. Any questions of the speaker? Again, in speaking with the planning department, have them see if they get you a copy of this grading and drainage plan. Looks like the proposed or the existing and the proposed drainage corridors remain as they are. But again, they would be able to help you with that more. Any other board members have any questions or comments of the speaker? All right. Is there anyone else in the audience who wishes to speak on this item? Just a moment. Seeing none, is there anyone online who wishes to speak or raise their hand?
We're not aware of anyone online.
All right. Thank you. I'll turn it back over to the applicant for 2 minutes for a rebuttal, if you can do it that quickly.
Does staff have the drainage plan from planning? There was a document, if I have it here, if we need to look at it, but there was a document that drainage put out that says that it passed drainage. We see that? Okay.
Mr. Chairman, for the record, for the folks in attendance, a grading and drainage plan is a public record. A building plan may not be for proprietary reasons, but a grading and drainage plan is because it's a public safety issue. And persons may submit a public record request online for copies of grading and drainage plans on a certain parcel number.
All right. Hope everyone caught that.
And I'd like to give them all the plans and talk to them and be friends. I'd like to do all of that. I would like to cooperate. And from what I've heard is that the leach fields, they need to move and planning needs to move. But I want to put the horse before the cart, and nothing is possible without width. So I've taken 2.5 years since I've owned this to get this far, to just try to get width. If width doesn't cooperate, then it is a lemon. let's do something else. And that's all.
All right. Definitely understood. All right. If seeing no one else, go ahead, Darren.
Mr. Chairman, sorry, just one interjection real quick. My understanding is the applicant hasn't applied for a construction permit for the house yet. So there's not a grading and drainage plan related to that construction. Engineering has signed off on the variance, which is kind of a non-issue.
Okay. All right. Thank you. So this is more of a preliminary grading and drainage that's in front of us. Okay. But still available and still shows topo. All right. Thank you. Closing the public hearing, turn it over to board members for discussion and possible motion. I'm going to say a few things. I am in favor of the variance for a number of reasons, not the least of which that the definition of where lot width is measured is a function of the zoning ordinance. Zoning ordinances are a one-size-fits-all approach because you can't have individual standards for every. How many parcels are there in the county, Darren? 8, 9 million, whatever it is. So they try to do the best they can. And there's situations like this and others where the definition can't be met, can never be met probably for this. Number two, I do believe it's a peculiar shape. It got a bowling alley kind of coming off 38th Avenue, and then it widens, and that's where the applicant has proposed to put his home, where it can meet setbacks otherwise. The Drainage corridor is another peculiar condition because if you look back at that preliminary grading plan, there's kind of a V area between the drainage corridors. One of the few places you could put a house. And while I am supportive of the applicant's attempt to move septic, I don't know that I would speak too quickly on your ability to do that because upstream, if you will, where there's a higher grade may not be a place that works. And this is one of those situations where the septic does count against the property in terms of disturbance, correct? In other words, where he disturbs for his leach field and the septic, that's the amount of disturbed area, whereas a driveway is not.
Mr. Chairman, not to make this sound more complicated than it is, but you can have, any lot may have up to 75,000 square foot of hillside disturbance. That's only the areas of hillside slope. It's, and that's everything, all disturbance. And it's limited to being within the principal building envelope as formed by the setback lines for the principal building, except for roadway, driveway, and utility connection.
Okay. But septic would be included in that for what's in the building area.
Septic is part of the disturbance calculation that needs to be less than 75,000 square feet. It needs to be within the principal building envelope.
Okay. You know, a side note, and I'm probably alone on this, but it would be potentially beneficial if there was such a thing as a septic easement that was put on the principal septic system and the leach field, because I, for one, believe that that's a hardship in the placement of where you can put things on a property, but it doesn't encumber the property like a regular easement would be, where we could consider it technically. I do, but not everyone does. Anyway, with that, I am in support of the variance as presented, and turn it over to other board members for discussion and or a motion. Member Schwartz.
Just to clarify, you're in support of it, including the additional disturbed area or just the width?
I'm in support of it for the lot width and the disturbed area. Those were the two parts of the request, correct? Yes.
Okay, because I thought that the owner said that he didn't need the extra, he would move the septic into the front, so he didn't need the additional disturbed area.
He may think that he can do that. We don't know yet. That's why I'm saying I'm in support of the variance as presented.
Okay. So thank you for clarifying that. So I'm only in support of this if we can solve the front setback line. And I think that there's a solution to that. I don't think there's enough of a peculiar condition because you bought the lot in the condition of what it was. This is just how the property is. It's not creating that. The ordinance says we have to have 140 feet. So if you can work out an arrangement with the property owner to the east to get, the enough distance to get you to 140 feet, then I think that your problem has been solved. And I think that it buys you a lot of goodwill with your neighbors. So I won't be in support of this, although I wish you the best of luck.
Thank you, member.
I am in support. I really wish there were a way to notify people in property records when there is a non-conforming land division. I don't even know if that's possible, but I'm saying it in case it is, because it would solve a lot of problems. But I am in support, and I would like to make a motion to approve case BA 2022-059, subject to the conditions outlined in the staff report, subject to the language outlined in the staff report.
We have a motion for approval by member Person. Before asking the second, I see member Cardin, you had a question?
Only to say second.
Oh, to say second. Member seconded by member Cardin. Rosalie, would you please take a roll call vote?
Member Cardin.
Yes.
Member Schwartz.
No.
Member Ward.
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes,
Chairman, that's an approval by a vote of 4-1.
go ahead.
I also just wanted to say thank you to the people that live in the neighborhood that came and spoke. And I want you to know that, I'm not ignoring your feedback, but I have faith that the county departments that review all of these plans and information are going to have those checks and balances to make sure that these concerns that you have are don't come to bear.
The mic one more time. I'll make it very brief. Track record is, I have not seen that. Track record wise. I've seen too many issues go overlooked in the area that I live. Too many. And I paid a lot of money for my permits. And I had to pay one for, I lived in a flood zone. And I couldn't get a permit because I lived in a flood zone, which I'm on a 14%. And I proved it. I haven't seen it yet.
Thank you, and we do, understand and sympathize with the comments for both of you. Don't forget to get cards from planning staff so you can get the contact information that you need. All right, move on to the next and final item on the agenda, item number 8, BA 2022-060, the Christman property. Mr. Landis.
Chairman Loper and members of the board, agenda item number 8 is for subject case BA 2022-060, which is a variance request for an RU43 zone property located 426.
Hold on a moment. Hey, if you could please take all conversations outside of the auditorium. It echoes like crazy in here.
Sir, it's still here.
Thank you. Proceed, Mr. Landis. Sorry about that.
Okay. That's a variance request for an RU43 zone property located 42615 North 13th Place in the New River area in Supervisory District 3. Approving this request would have the effect of allowing for a 45-foot rear setback where 65 feet is the minimum permitted due to the existence of a 25-foot future right-of-way reservation along the south parcel line due to a section line alignment. This would allow for the permitting of a single-family residence and detached accessory structure. Next slide, please. The subject lot was created as part of an unregulated minor land division in the mid-2000s and has subsequently remained undeveloped. The lot is of a home plate or diamond shape and is subject to hillside conditions on the eastern half of the parcel, as well as the section line alignment along the south. Prior attempts developing the property led to the reduction of section line alignment from 65 feet to 25 feet due to the rugged site conditions surrounding this and adjacent parcels. Next slide, please. The current owner came into possession of this site in 2019 and began the process of permitting the proposed residence and accessory structure in August of 2020. As of the publishing of the staff report, the subject permits are in their 7th review cycle with continual issues relating to the placement of the structures in the lot. Next slide, please. Staff would note that approving this variance with a 45-foot south setback would not allow for the permitting of the structures presented in the site plan. Staff has measured each of these structures to be approximately 40 feet from the south parcel line, whereas the applicant is asking for a 45-foot south front. Given the circumstances previously mentioned, staff is recommending to the board that if they choose to approve this variance request, they approve a 15-foot variance to equal 40 feet rather than a 20-foot variance to equal 45 feet from the south parcel line. This would allow for the permitting of the structures at their current bounds rather than having to subject the applicant to further plan review cycles. However, the staff is recommending denial on BA 2022-060 as the hillside conditions and section lines are not peculiar conditions unique to the site itself, but rather common to all parcels along the section line alignment. Second, there exist alternatives to the site design that would allow for the applicant to meet the existing setback requirements. Finally, these conditions were self-created in the line of title as the lot was created as the result of an unregulated land division. If the board finds that the applicant has proven entitlement to the variance, then the board must state on the record the basis for that determination, with findings and conclusion in the motion to grant the relief sought. And at this time, I'm happy to answer any questions.
Thank you, Mr. Landis. To confirm, the front of this lot is the bottom of this photo.
So this would be considered a through lot. So there's actually 2 fronts, both on the north, and you see the kind of diamond shape there. Those, both the northwestern line and the northeastern line would be considered fronts as well. as well as the south, because of the right-of-way alignment, that would also be considered a front. So there's two fronts ultimately, but the north and south, anywhere from where the property line is.
So three of the 5 property
Yes,
lines.
you could say 3.
All right, you have to meet the setback. Okay. All right, any questions of staff? Member Person?
Mr. Landis, did you say that this was another unregulated lot split?
That's correct.
Okay, thank you.
As a add-on to that, I was just commenting to Member Schwartz that I think we've had this lot shape in front of us every month for the last X number of years. Anyway, any other questions of any of the board members of staff? Right?
Mr. Chairman, could I?
Yes, sir.
Something? In the staff report, there was a recommendation that if you're inclined to approve it, that you approve a different variance.
So it would be a 40-foot south instead of a 45-foot south.
In order to do that, you would have to get the applicant to agree to amend his application. You don't have the power to grant a variance that wasn't applied for. So if you end up going that way, I thought I'd let you know upfront so you can handle it rather than get into a morass. And
No, I appreciate the clarification on that. Thank you.
plus, I like to look like Kilroy with this high podium.
I think it's going to fall over if anybody attempts to move it. All right, I'm going to open the public hearing. Is the applicant or applicant representative here? If you could please come to the front and provide your name for the record, please.
All right, my name is James Chrisman, and I've been working on a permit now for 2.5 years. I was told I had a 40-foot setback, and I designed the house to fit topography at 40 feet. To move it would be a total redesign of the house. I mean, it's not something you can just slide forward, because once you start sliding forward, you start dropping downhill, and that means redesign everything. And I just can't. I can't. I can't spend another 2.5 years trying to get this going. I mean, I plan to leave 1/3 natural desert because that's the way I designed it. I want to be able to look out my window and see the desert. I don't want to bulldoze it and have to build a house there. You know, it was made years ago. Someone had a barn there. I took the barn down. That's where I want to put the house. It's flat. Lower than that, it's a horse corral. It's flat. I can't see tearing up natural vegetation when I've got 2 flat spots to put a building. So I hope you'll help me.
Any questions of the applicant? Member Person?
Hi there. Where did you get the information about the 40-foot setback?
Looking online through the county records, it was 40-foot setback. I didn't know there was a right-of-way there at that time. I wasn't informed till almost 1.5 years later that there was also a right-of-way back there.
Okay, is that related to this 55 to 25?
Yeah, right.
That is correct. To give some background, the property, when it was split in the mid-2000s, there was a prior property owner who attempted to develop it, I believe in 2008. At that time, they had applied for the right-of-way reservation and had it reduced from, I think it was 65 originally to 25. And I guess in the course of permitting, that came about. But I don't think anybody would really be aware of that unless they'd apply for the permits, and we'd let them know.
Now, one difference is my neighbors are wondering when I'm going to start. They're not complaining about what I'm going to build. So, but the neighbor to my west actually owns the whole face of the mountain behind me. So the chance of that right of way ever being used are pretty slim.
I do have a question of you. Mr. Peck had come up and mentioned that in the staff report, it talks about that the setback to the south would need to be at 40 feet. But it takes you stating publicly that that's your request.
It is my request. Well, what initially happened is I set it to 40 feet, and then I spoke to someone. They said, no, it needs to go down another 5 feet to make it work with the drawings I have existing. So that's where that other 5 feet comes in. And I asked if I would have to resubmit, and they said, no, it can all be handled here.
Mr. Chairman, we just need him on the record to say that he's requesting a 40-foot south setback rather than 45.
Could you request that? Did you
request 40 foot instead of 45?
For the southern property line?
with the southern property line.
All right. Good. We got it. Our attorney's happy, he's smiling, so that's always a
As long
good
as he's
thing.
happy and everybody else is happy. Make me happy.
Any other questions of the applicant from anybody? All right, if you'll hang tight. This is a public hearing that I opened. Is there anybody in the audience who wishes to speak on this? I have no cards. There's nobody left. Is there anyone online who wishes to speak?
We're not aware of anyone online.
All right, thank you. I'll go ahead and close the public hearing. And I will turn it over to the board for discussion and or a motion. This is in, what district is this in? Three, member persons.
Thank you, Greg. I do think that these goofy shaped lots present a peculiar condition, and that's maybe not the shared opinion, but in my opinion, they leave very limited ability to develop what you want to develop. I understand that it got that way in a way that wasn't supposed to happen. And to my comment on the last case, I wish there were some way of notifying people ahead of time, kind of like when you buy in an area where it's close to an airport and you get that advisory, you know, so that it's on the record when they buy it. But that being said, I'm in favor, and I would move that we approve case BA 2022-060, subject to the language outlined in the staff report and applicant's statement of the 40 feet versus 45 on the south property line.
We have a motion for approval by member person. Let me get the second. I'll open it up for discussion. Is there a second?
Second.
Second by member Cardin. And discussion, go ahead, Schwartz.
So I just want to go on the record that I'm applying the same standards as I did for the lot before, that somebody created the lot condition. The lot condition didn't create the peculiar condition. In this case, and I try to send everything out with love. Sometimes it's tough love, but it's not our job when somebody goes on to the website, makes their determination without getting an engineer or an architect to accurately confirm it, to solve the fact that they need to redesign the house. There's ways to configure a house on this lot without asking for a variance. And it's not our role to be so sympathetic that we have to set aside what our standards are for considering a peculiar condition. Again, this was a people that created this condition. It wasn't the land. And so I'm opposed to it only because I think that there's other options for you to design a house. I'm sympathetic that it took 2.5 years to where you've gotten to today, but there is a fix to it. I built a lot of houses in the hillside. There's creative ways to solve this. So I'm not going to be in favor of a motion.
Understood. And my only comment to that, not even hopefully I don't sound argumentative, but as Mr. Peck has attested, there's not a statutory provision for the county to get ahead of these minor land divisions. So we are stuck with lots that have weird shapes, as this one in the previous case did, which to me are peculiar conditions. They aren't necessarily created by the applicant. They may be buying the property knowing its shape, but this is the vehicle to try to make it work within the zoning and the standards for Maricopa County. And I like to see the utility of a property rather than have it remain vacant in perpetuity. I like that you're attempting to do something with it. So with that, I am in favor, and I will, sure, go right ahead.
All right, and I don't want to be argumentative either, but we all, when we buy property, have to do our due diligence. And proper due diligence would have determined that this did not meet the guidelines of a lot that could be built upon. And so whenever I buy property, I go through that due diligence period. If there's a problem that I need to get it solved, I have a contingency to go through the process because I don't want to own something I can't use. And so I go back to what I said before. And obviously, there's a debate here and discussion, and we disagree to disagree on things. But
absolutely,
when we leave the pitch, we go drink beer. So we're going to be leaving the pitch in a few minutes. So thank you.
All right, with that, Rosalie, if you please take a roll call vote.
Member Cardon,
Yes.
Member Schwartz,
No.
Member Ward,
Yes.
Vice Chairperson,
Yes.
Chairman Loper.
Yes.
Chairman, that's an approval by a vote of 4-1.
Congratulations. Good luck with your home.
Yes. Yeah. Good luck to you.
Thank you. And that concludes our hearing. Is there anything that needs to be presented by staff or, all right? Adjourned.
Thank you.